I'm Alexandra Monkhouse, lawyer at Monkhouse Law Employment Lawyers, and today we will discuss at-will employment in Canada. In Canada, unlike in the United States, there's no concept of at-will employment. Most employment contracts in Canada are considered indefinite, meaning that they can only be terminated by the employer with reasonable notice or pay in lieu thereof, unless specified otherwise in a fixed-term contract. At-will clauses in employment contracts in Canada are illegal. While at-will clauses do occasionally appear in Canadian contracts, often due to U.S. companies operating in the country, courts will void such clauses and replace them with contracts of indefinite duration, terminable only by reasonable notice. In Ontario, as in the rest of Canada, employers are obliged to provide reasonable notice or pay in lieu thereof upon termination, unless there is just cause for dismissal. The law of reasonable notice evolved in the 1960s, establishing that employers must provide reasonable notice or pay in lieu thereof, unless there is just cause for termination or an enforceable termination clause in the contract. Employees cannot be fired without reason in Canada, and even if they signed an at-will contract. In a notable Court of Appeal case, an employee was awarded compensation after her termination despite an at-will clause, as it conflicted with her entitlements under minimum provincial standards. In conclusion, it's crucial for employees to be aware of their rights regarding employment contracts and seek legal advice, if necessary, to ensure that those rights are protected.